a company law. One thing that I can assure all of you is I'm not interested in the grades you are going to get, because there is a guarantee that with a little effort, all of you are going to pass. And so I don't want any panic situation, any of you to panic. Remember, it is the knowledge acquisition that you should be interested in, because you will also need the knowledge to be able to impart. And so let us dwell more on the knowledge acquisition. With the little effort that we put in, our passes are guaranteed. The quality of the passes, however, will depend on the end of semester. As for the pass mark, everybody will get it. But if you want to get an A, then you will have to work extra hard to get your A. If you want to maintain your pass mark, that is the D, then once you attend classes and you listen to whatever we're going through, then your pass is guaranteed. But I know most of you wouldn't want just a pass, but you would want a good pass, so that you can use that to set an example for others to follow. So we shall be going through company law in Ghana, and there are a lot of topics that we will be treating. And hopefully after the class, I will forward to you the course outline. I'll send you the course outline. And the course outline is supposed to look at, we are supposed to look at these issues. The introduction, that is what you are going to do, that the history, an overview of company law in Ghana. Then we look at company formation. We look at promoters and pre-incorporation contracts. Then we can look at the powers of company. Then we look at the nature of legal personality and the veil of incorporation. Then we look at the constitution, internal management principle, where we will make reference to what we refer to as the rule in Turquoise versus Royal British, that's the Royal British Bank Limited versus Turquoise. That is what we normally use when we are talking about internal management and the presumption of regularity. We will also look at the officers of the company, and then you look at the secretary and that of the auditor. Auditors are not considered officers, but they play a key role in the governance of the company, so as company secretaries as well as directors. So directors are officers, depending on how the secretary is appointed, can also become the auditor. Then we'll also look at the members, and then we'll look at the diomatic principle, that is the ratification principle. And there we'll get to know that rectification and ratification are two different concepts. And even when we are treating promoters, you will understand what you mean by ratification, not the same as rectification. Rectification is talking about correcting a document, and ratification talks about accepting responsibility for certain actions. There is also issues of the company's securities. By security, we are not referring to the man standing by the gate, but we are looking at the sources of finance that the company can rely on to undertake its transactions. And so we'll be looking at shares, debentures, and then liquidation, and then everything with partnership. So it is packed. And you will have to do a lot of reading. You will have to do a lot of reading. So after every meeting, you will have to do a lot of reading. How many meetings in all are we supposed to have?
Four.
Hello, class. How many meetings in all? Four. So I hope by the fourth meeting, you would have covered as many topics as possible, and you would have also read as much as possible. It's going to be a smooth journey. I wouldn't want to overburden you, because I know you are already working, you are already teaching, and we are all colleagues. And so as colleagues, I cannot treat you differently. I have to treat you as my own colleagues. And then I will only respectfully ask you to do one or two things, and then we are all on the same page, and then we can move on. Do not think about grades, because you pass. but think about acquiring the knowledge so that you can also impact positively on your students, as we are all doing. But on this platform, we treat ourselves as colleagues. So we look at history of company law, and by history of company law, we are looking at how the present company law, which is governed by the Act 992, which was passed in 2019, has evolved. As a country, as Ghana, there are three legal regimes. Three legal regimes. We are looking at the Companies Ordinance 1907, the Companies Code, which was passed in 1963, and the new Companies Act. That is the current act, which is now regulating the activities of companies. And even with the recent act, there has been a judgment of the court modifying some aspects of the acts. There's a judgment of the court which has modified the act that was passed in 2019 regarding that has to do with the human rights issue, and we'll look at that together. I'll send you the judgment of the Rekadijemfi. You look at it, where he challenged some portions of the act, the writing of the portion of the act, which the Supreme Court also agreed with him with his position. And based on that, that portion has been struck out by the Supreme Court. And we all know the role of the Supreme Court when it comes to shaping and providing direction in terms of law. And so there are three basic legal regimes that has governed the evolution of the current act, which is the Act 992, which was passed in 2019. So the first act or the first legislation to regulate companies was in 1907, which referred to as the Companies Ordinance. And that at that time, it was a carbon copy of the then regulations of our colonial masters, that's the British. And so just before we had started using it, the British saw the inadequacies in that act, and they were about to abolish or discard it. That was when we decided to go in for that particular act. That was when we decided to go in for that particular act. And once we gained independence in 1957, just a year after independence, the then president thought it wise that we needed to have a legislation that regulated the activities of companies, because at that time, commerce was booming. And so there was a need for us to have a legislation that regulated the activities of companies. And the old one that we were using, which was a carbon copy of the British, which they have already discarded, also meant that there was a need for us to also discard the Companies Act, that's the Companies Ordinance, which we were using then. And so that led to the appointment of a noble person referred to as, normally people call him Professor Gower. And that is Professor Lawrence Cecil Bartlett Gower. Take note of these, because that is historical development, and historical development questions about it are very key, because you cannot talk about company law in Ghana and forget the key contribution of Professor Lawrence Cecil Bartlett Gower. Normally, we cut a short Professor Gower's report. So he was appointed the sole commissioner, and his report culminated into the passage of the 1963 Companies Code. And he, as he indicated, he wanted to have a codified law. And a codified law means that every law related to companies was brought under one umbrella. And that was what Ghana was one of the few countries at that time, even ahead of the British, to have had the code. And that the code was to bring everything related to companies under one act, and that was the Companies Code, which was passed in 1963, and it was the Act 179. Now, 50 years on, 50 years after we had passed the Companies Act, that's the Act 179, Act of 1963, there was the need to also look at whether the legislation that was passed 50 years ago, portions of it were still applicable to our current dispensation, looking at developments that has taken place. And so there were a number of initiatives which began during the term of President Kufuor by the appointment of some eminent members of society to look at it, of which Professor Bonzi Simpson, my former boss, was part. And there was this Professor Mackenzie, who was the external consultant. Professor Justice Datiba was also involved. At that time, Member of Commerce, one in charge of the president for, I think, Guta at that time, was it Guta, was also involved. One Otin Jesse was also part. The registry of companies at that time was also involved. And so they had a series of meetings. And this series of meetings is what culminated into the present day Companies Act that we are using. And the present day Companies Act had to now look at our situation and come out with something that will suit us. And so there are some aspects of our Companies Act that do not conform to what the British were doing, because we sought to localize or to contextualize the law to be relevant to our local setting. So a number of developments has taken place, as I indicated. And so the 2019 Act sought to modernize the legal framework, and also enhance corporate governance and improve investor protection. So the end result is that we want to have a Companies Act that is contextualized, that is modernized, can stand the test of time, that also protects and ensures corporate governance. And by corporate governance, we are looking at checks and balances within the corporate world. And by checks and balances, just like we have in our constitution, where we have the arms of government all performing a significant role, the checks and balances that the corporate governance in the Companies Act identifies the key actors within the corporation and ensures that everybody serves as a check. So when you look at the appointment of auditors, and by auditors, we are not referring to the internal auditors, we are referring to external auditors. And the arrangement is that it is we, the members of that company, that appoints the auditors. And when the auditors are appointed, they are supposed to report on how directors, the directors are the people whom we as members mandated and entrusted in their care resources of the company to manage the activities of the firm. And so at any point in time, the directors should be made accountable. And so the auditors will now look at the activities of these directors, what they've been able to do, and report to back whether the monies were entrusted in their care, they used it in a way that they ought to have used it. And so once they send a report to us, we can then make a determination whether to renew the mandate of the auditors or not. And so realize that corporate governance in this sense is enhanced. So a director cannot be appointed, misuse the resources of the firm, and will not go unpunished. The auditors, the external auditors, will review that. And the revelation by the external auditors is an indication of how well the resources have been used. And that is how members are able to check on the people that they appoint to manage the affairs of the company. So Professor Gawa is a distinguished academic. There is a history to it where he was born in East London and was educated as a solicitor, a professor of commercial law, and he was even a visiting professor at Harvard. And he did a lot of things. So as I indicated, in 1958, a year after independence, the government of Ghana set up a commission of inquiry, and the goal of the commission of inquiry was to look at the current law, which was the 1907 Companies Ordinance, which was a carbon copy of the then British law, and to make recommendation for either the amendment or the complete overhaul of the ordinance. And Gawa came out with a report, and that was the He was a sole commissioner. Sole commissioner meaning that he was the only person appointed as the commissioner. And so, and his tax was taken into account the need for encouraging African enterprise in Ghana and the encouragement of foreign investment. And so Professor Agawa did a lot. And his first observation after being tasked was to review the 1907 ordinance, which was the current English companies legislation. And he realized that that legislation was unsuitable for Ghana. But Ghana law must adhere to a number of these familiar English models. And so because of the legal regime or the legal system that we adopted, so we needed to conform to some aspects of the British law, but he realized that the content of the legislation was unsuitable to us. And so his initial viewpoint was to critique the former colonies, that's the masters of our time. And he did a number of these and identified a number of deficiencies in the colonial legacy and indicated indicated those critiques in his report. And that in itself was part of the work that Professor Gawa did. And so he was looking at some of the things that he saw was that he made it clear that he was more inclined towards moving the direction of scrapping the ordinance altogether rather than amending it. So from the onset, Gawa saw that the law, the company's ordinance then was unsuitable. And so with his observation, realized a number of the issues in it were not conducive and were not contextualized enough to address our peculiar concerns. And so his goal was to ensure a scrapping than to amend. The amendment would have meant that those portions that he thought were suitable would have been corrected or changed, varied to suit. But he was rather looking at the entirety of the whole document and then try to scrap it. And his justification for the scrapping of the ordinance was that 50 years when we had adopted what the British were about to discard. And so 50 years, he thought that it was too old. That was one. And even the people that we adopted this, they had seen that to be unsuited and were planning of discarding it. And so he was inclined to go towards that direction. And so in 1962, when his report came, and his report was what led to the replacement or repealing or scrapping of the 1907 ordinance. And that was replaced by the Act 179 of 1963. And some portions of it were revised and was given, the presidential assent was not 2nd August 2019. It was rather, so his report led to the passage of the 1963, that's the Act 179. And subsequently, 50 years after that, there was a need for us to also look into those laws. And that was when President Kufuor, in his wisdom, started to appoint some eminent people who then also decided to look into it. And their recommendation is what led to the passage of the 2019 Act, which was passed in 1992 and was given presidential assent on 2nd August. As I said, even in its recent stage, portions of it were taken to the Supreme Court where the petitioners were challenging some aspects of the law. And I would want us to have a look at that, where the petitioners challenge an aspect of the law. And I would later, either I'll send it to you or we'll look at it together. So currently, the act that regulates the activities of companies is the 2019 Companies Act 2019, Act 992. And that is the act that establishes the Office of the Registrar of Companies and responsible for matters that are related to companies. At this point, let me pause, and if there is any question, we can ask. At this point, any question? Hello? Are we there?
Yes, Doc, we
Yes,
are here.
please.
Yes,
Yeah.
please.
I
We are
hope you are
here.
following me.
Yes,
Yes,
sir.
please.
Yes, Doc.
So, teachers will normally ask one of their own to summarize what has been done so far. Will it also be right for me to also ask one of you to summarize what you've done so far? At least your summary should highlight the key legislations that the evolution or the key legislations pertaining to companies in Ghana and how we arrived at the present legislation, that is the Act 992 of 2019. Who will help us with that? Should I mention names? Letitia Beku. They say ladies first, so at least I should be able to mention the ladies first in all things. So ladies first. So Letitia Beku. Letitia Beku, are you online? If Letitia is not there, Aminu Halidu. Hey, Catherine Minta. The graft, your hand is up. You can talk.
Oh, yes, sir. Please, just now that I've joined.
Okay, sorry. Okay,
Thank you,
let's
sir.
look at Anita Afro Esiedu. One of my mates was called Afro. So that is why I'm calling Afro Anita Afro Esiedu. Are you there?
Well, I'm here. Please, I just joined. Good morning.
Hey, good morning. Awate Benjamin. I hope you did not just join. Letitia Beko, come back. Oh. I guess so that Letitia has left the meeting, but Letitia will have to come back. Anyway, let me continue. So all that we've said is that we have the present Act of 2019, which was Act 992. But there is a historical antecedent to the passage of the Act 992. We had the 1907, which was the act that we were using, and that was the first legislation that was passed to regulate the activities of companies. Ghana, after attaining independence in 1957, thought that we needed to have a legislation that is contextualized and that will be able to deal with matters in Ghana. And that also led to the passage or to the appointment of a sole commissioner, Professor Cecil Bartlett Gower, and whose report culminated into the passage of the Act 179 of 1963. 50 years then, we also realized that there was a need to look into the law because a number of the issues in it were becoming outdated, and we needed to have a law that was modernized to deal with our present issues. And that led to the passage of Act 992, and which was given the presidential assent in August 2019. Remember, these are historical developments. And so in quizzes, for example, all these questions will be asked. And so let's take notes and learn. Now, having understood some of these historical developments, I will forward the document from Justice Databa on revitalizing Gawa's legacy, reforming company law in Ghana. I'll forward that document to you. Letitia, welcome back. of late students
Thank
on my
you.
online. Thank you. I asked a question. Can you help us? I was waiting for you to come back.
Doc, what question?
I wanted you to summarize what you've done so far.
Doc,
It's
the
going to be.
network wasn't good at my side, though, so I was even moving around to get whether I can get.
It's okay. It's okay. I've done the summary myself. Thank you for coming back.
Thank you.
Okay, so anytime we talk about the word company, we are looking at an association between individuals. When we begin to go into the provisions or the sections, there you will see that it's an association of two or more people, one or more persons, because one person can form a company. But the idea is that more than a person or people coming together for a common purpose. And that is what we mean by company. There are a number of categories of companies. We have the profit-making companies and then the non-profit-making company. And when we go into the act itself, you will identify those companies that are considered profit-making and those companies that are considered non-profit. And these companies are operating. Those whose sole aim is to make profit, and those whose sole aim is not to make profit, but to provide certain service. And later we get to know companies limited by guarantee. And we'll make a distinction between companies limited by guarantee with companies limited by shares or unlimited liability company. And we will understand that the limited by shares or limited liability companies are created for purposes of profit, whereas companies limited by guarantee are for non-profit making companies. And so you will understand it. Again, companies may be incorporated or unincorporated. But remember that our act deals with incorporated companies. And I will also forward the act to you. That's the Act 992. The Act 992, that is the act that regulates. If you look at what I just showed, where the act under Section 9, 1 makes a distinction between incorporated and unincorporated companies. And that is when the Companies Act tries to distinguish between companies limited by shares and the different types of companies. And it also talks about those companies that we can talk about incorporated. An incorporated company is a company that goes through a process before it is given birth. And the Act talks about incorporated companies, and their birth is signaled by the issuance of a certificate. And the certificate is an indication that the company has been given birth to and that it can begin to work. And that is what it does. An unincorporated company do not go through such processes. And that is one of the key distinctions. And so it has no separate legal existence from its members. We see the members and everybody as one. And that is where, if the company owes, unlike a limited liability company that is an incorporated entity, there is a distinction and there is a legislation that makes a distinction between the people whose funds started the business and the people who are managing the business. And so when you look at it, we, the class members, can come together to make a contribution to form a company. We made the contributions. But once we create an entity, that entity is not ours. That entity stands on its own because it is just like giving birth. The child is your blood, but the child has his own brain, has his own everything to do anything that he wants to do. The only thing that you are doing is to manage. But as to whatever decisions the child takes, that is the responsibility of the child. And so once we may have contributed to establish the company, once the company is created, we are distinct and we are separate from the company. And that is what you mean by that. It has a separate legal entity, whereas an unincorporated entity do not have that separation. And in that case, if the company has any debts in an incorporated entity, we distinguish between the assets of the company and we, the people, our personal assets. And so it is the assets of the company that will be attached to defray the debt and not our personal assets. And that is one key distinction, which later we shall be looking at. And so in Ghana, company law has three key aspects. And the three key aspects, we are looking at the statutory provision, which is the Companies Act. And it is also shaped by judicial decision. That is where we look at case law. And so very soon we shall be making reference to case law. And by case law, we are looking at decisions of the court, pronouncement by the courts regarding the affairs of companies. And we'll also look at some theoretical concepts like the veil of incorporation, which these theoretical concepts talks about the reasoning behind how things are done in companies. And this reasoning is what some of the judges take into account. And this same reasoning is what underpins the framers of the legislation. They are thinking about certain aspects of it. And so we'll be looking at that. But let us note that our Companies Act or the Companies Law in Ghana has sections or provisions that addresses the Act itself, that the statutory provisions, case law, and the theoretical underpinning of the whole area of law. So what are the key features of a company? Based on what we've had, it has its own legal entity separate from that of the human beings who are involved in the company. And that was why, one of the reasons why we normally refer to it as an incorporated entity. We can also talk about the owners of the company have limited liability. What it means is that if the company owes, they cannot come and sell my house fridge to defray the debts of the company, because we've made a distinction between the assets of the company and that of the people that started the company. So if the company is owing, it is rather the assets of the company. And me, as a member of the company that started, if the company owns a car, that is not my car. It is that car belongs to the company. And so that distinction is also made. And there is the separation of ownership. That's where we have the members, we are the owners. But we do not manage the affairs of the company. The affairs of the companies are managed by directors. And as I indicated, all the assets of the company are owned by the company. And that distinction between the assets of the company and that of the members is what we make it, that is what we refer to as the separate legal entity. Going forward, we can talk about contracts are conducted or defended in the company's name, not that of the humans who are involved. So, assuming your headmaster, the headmaster of your school, enters into a contract in his capacity on behalf of the school, in his capacity as headmaster of the school, even though the person is Mr. Awate, Mr. Awate is not the person that entered the contract. Mr. Awate only acted on behalf of the school. And so when you come to UCC, for example, our Vice Chancellor, Professor Boampo, if he does anything, in the name of the university, it is considered the act of the university. Likewise, as I'm teaching you, should I do anything untoward? I wouldn't have had the chance to do that if I were not appointed a lecturer and performing my work as a lecturer. Should you decide to bring an action against me in the course of my official duty, that action will be responded to by the lawyers of UCC and not me, because that action is not against me as a person. It is against the institution that I work for. And that is when we talk about UCC can enter into a contract on this one because we consider UCC as an entity, as a human being itself that can enter into a contract on this in its own name, and that's a number of things in its own name. Orders and obligations owed to third parties are owed by the company itself and not. And so the fact that you've seen me as a director and the company owes, you cannot stop me and seize my car. That is my personal car. And so if you think the company owes you, take the action against the company and recover your property from the company. And that is when we talk about orders and obligations owed to third parties are owed by the company itself and not by the members or directors. There is transferability of ownership. And so I can, if I bought shares to become a part owner of the company, I can transfer that shares to another person. So Letitia Beko can purchase shares of that company, like what most of you did recently when MTN floated the shares. At any point, you can sell the shares. And once you sell your shares, you have transferred your ownership to the person that you've sold your shares to, or to the person that bought the shares. And that's why I talk about transferability. But the transferability of shares, there are some restrictions depending on the type of company that it is. And later, that is what we'll be looking at. There is perpetual succession, and these are all key attributes of a company. The fact that member A is not around, like those that bought the shares of MTN, it may even happen that none of them may be living again. But as MTN collapsed, some of them have died, some of them are no longer around, they are no longer amongst the living. But the MTN is still working. And that's an indication that the death of either a director, the death of either a member of the company does not bring to an end the activities of the company. The company continues to live, and that is when we talk about the perpetual succession. It can raise money by borrowing, just like you can borrow. Companies can also borrow. But we refer to the security under which they can borrow. That's why we'll be talking about debentures. So when I was talking about securities, shares, debentures. Debenture is the tool that they use to borrow from you. The shares is different because with shares, you are making a contribution. The company is not borrowing from you. And there's a distinction. If the company borrows from you, I am a creditor. But if I buy the shares of the company, I am a member of the company. And these are all parts of the different the distinction between shares and debentures. And later we'll be looking at all of them. It can create floating charges over the company's assets, which can enable it to borrow. No, you see, whenever you borrow, they ask you to provide a security for the amount that you are borrowing. And that is what they refer to as a charge. And that is when they talk about a floating charge, providing security, using part of the assets of the company as security to the amount that the company may have borrowed from you. And so they will provide a floating security. And the floating security does not mean that what they have provided as security, the company cannot use it, because the company must work to be able to pay for the debt. And so if they create a floating charge, it allows them to use those assets that they provide as securities to still trade, so that they'll be able to raise money to pay. But there are rules that guides or governs the use of such assets that has been used as a charge over loans that the company might have borrowed. So based on all these, we can talk about the benefits of a company. And by the benefits of the company,
Hello, Doctor.
Yes, sir.
Okay, good morning, sir.
Good morning.
Doc, on the issue of the legal entity, I want to find out the case of is it at Atu Asian or Atu Esuma in the Capital Bank case?
Yeah.
At which point did he commit that offense? I don't know whether he was acting in favor of the company or in his own accord. That he
Okay.
Yeah.
Later, you get to that separation is a protection given to the directors. But you get to know, for example, if the state thinks that the company has committed a crime, per the separate legal entity, the state will have to take an action against the company. But you know that companies do not have legs, neither do they have mouth. It is through persons that administer the affairs of the company. But if the state decides to target the company, they cannot get any human beings. But for the state to know who are those behind the company, or who are those that use the company as a vehicle to commit those crimes, that is when the state will do something we call lifting the veil of incorporation. Once you lift the veil of incorporation, you have taken away what used to separate the company from the directors and from the members. And it is at this point that you can now see that Atuesian was the one that used the company's name or used the company to secure the loan. Then we can deal with Atuesian. And it is part of the things that you'll be doing, lifting the veil of incorporation. And the law makes room for instances under which the veil can be lifted so that these individuals can be identified. Like the example that I gave of a headmaster signing a contract on behalf of a school. If there is a default, it is not the headmaster that you are going to sue. You are going to sue the school. If you sue the school, you only come and see the building. But for you to find out who was behind that fraudulent contract, you have to now unveil to see those behind, then you can direct your actions towards them. And for you to be able to do that, you need to lift the veil of incorporation, which is one of the key topics that you'll be treating. And you look at those instances under which the veil will be lifted so that those individuals can be ascribed with liability and punished for their involvement in or in the affairs of companies. Are you okay?
Yes, sir.
Please, are you okay?
Yes, please.
Okay. So in most of these instances where you see directors of companies, then they'll be talking about lifting the veil of incorporation so they can identify these people and deal with them. So what are the benefits of creating a company? As you can see on your screen, you can talk about separate property. Separate property. You can talk about perpetual existence, which you've explained. We can talk about legal actions that the company is responsible for assets and liabilities. It can be sued and sued. Limited liabilities, where the members are not liable. But for you to now identify them, you have to lift the veil, which you'll be looking at. But it's a benefit. Borrowing, the company can contract loans, create accounts in its own name. And we can also talk about transferability of interest. And so, but there are some demerits. The technical formation. To be able to establish a company, you need to go through some technical processes. In some cases, you need to get an auditor, you need to get a lawyer, and you need to understand this technical regime. And that makes it a little bit difficult. And that is why once you have your own money, you go in for the sole proprietorship, which is unincorporated. Then you go, the processes to establish the company is also costly because it involves some financial requirements. In some cases, you may have to purchase shares and they have to see the amount in the accounts. And you also lack control because even if you created it, you need to appoint board of directors. And the board of directors are the ones that administers or controls the affairs of the company. And what it means is that if you yourself, you don't appoint yourself as part of the directors, you cannot exercise that control over the company. It will have to be administered on your behalf. And later that they can report to you for you to take an action. There's nothing like privacy because everything becomes known to every member of the company. These are some few demerits that we can talk about. So in Ghana, you can only form a company by registering it under the provisions of the Companies Act, which we will be going through together. Kindly take note that companies formed for special purposes. We are looking at banking. You know, if we're establishing a company for banking, it comes under two legislations. The aspect of it for companies will have to be regulated by the Companies Act. But for the aspect of it for the special business will have to be regulated. The business that it wants to undertake will be under the domain of the area or of the sector. And that is where the Bank of Ghana comes in. And so the Act does not abrogate or affect legislation relating to companies carrying on the business of banking insurance. It's still applicable, but just that the sector that they find themselves, the acts that regulates their activities, will be given priority when it comes to a problem. They'll rather use the Sectors Act to take they'll use the Sectors Act in managing the business of the company in that sector. But when it comes to the general operation coming under the company, then the Companies Act comes. So if we're a bank, you'll be regulated by two legislation. That is the Companies Act, because it has to come under the umbrella of a company. And that is a requirement that the Banking Act has also admitted in the Act. And subsequently, it will also come under the Banking Act itself, where you'll be regulated by your sector minister. The sector regulators are there to regulate your activities. And so we can look at the case of Paul Wood Treatment Limited versus Asari, where Sophia Akofo, the past CJ, reiterated this policy by pointing out that the company only comes alive when it receives the registered certificate of incorporation. So if you're a bank, you cannot say that you comply with the banking regulations, and so you can. The Banking Act says that you must be a registered company. And so before you can even trade or engage in the banking business, you should have been issued the certificate of incorporation from the registrar. That is what signals that you have been given birth to. And that is what will allow you to go into the banking sector to do the business that you want the company to undertake. And so on this note, that is the brief summary of the history and aspects of company law. So I'll pause here before I move on to other aspects, which you will be looking at very, very soon. Questions, class? Hello, class. Question.
Doc, we are here.
Do you understand?
Yes, Doc,
Yes,
we are
sir. I don't want us to go along that line.
here.
Please, we
Okay,
can continue for now.
we can continue for now.
Yes, please.
Okay. So let's look at the course outline. You're supposed to look at formation of companies. Let me project that one too. Those of you with smartphones, how can I send this thing to you, the acts? So I can put it on the platform.
Yes, Doc.
Yes, Doc.
Let me put the acts on the platform so you can access, because some of you are going to read portions of the acts for me. So that it doesn't become like I'm the only talkative on the platform. All of us are talkative. We are all in the same business of teaching. Aren't we?
Yes, we are.
And we are all talkatives. Okay, I have it here now. Now let me I'm coming. I want to I've put something, I don't know if it is the right platform. Yeah, that's not the right platform. Please a minute. Okay, I've seen SBU.
SBU303D.
SBU303D.
Yes, that's the
Okay.
platform.
What are some of the names that I can see? Is Evangelist Hammond part of it?
Yes, Doc. I am the Andrew JC, sir.
Okay, then let me quickly. A minute. Okay. Is it there?
Not yet.
Not yet. Hey. Then where did I put it? Just I thought I had just sent it to.
Yes, Doc. It has come.
It has come in.
Yes,
Yes,
it
sir.
has come.
So that is the act. That is the act itself, which we are going to use to explain where we are now. So next is for us to look at formation. And by formation, we are going to look at formation of companies. And so we are going to look at the companies limited by shares or limited liability companies, companies limited by guarantee. And then we go ahead to make a distinction between public and private companies. Now, when you look at the Act under Section 6, it talks about one or more persons may form an incorporated company under the Act. And it goes further under Section 7.1 that Act 992 provides for the following types of companies: a company limited by shares, a company limited by guarantee, an unlimited liability company, and an external company. Then it goes under Section 7.4. It talks about any of the above may be a private company or a public company. Now, let's first go into it. So we are now going to look at the company that is limited by shares. What we mean by a company limited by shares, what we mean by a company limited by guarantee, and what we mean by an unlimited company, and then what we also mean by an external company. If you have the Act, please kindly scroll to Section 7. Those of you with the Act, kindly scroll to Section 7. So Section 7.1, Section 7, subsection 1, A, B, C, D talks about the types of companies. So when you are asked of the types of companies that can be incorporated in Ghana, making reference to section 6, where it talks about one or more persons may form an incorporated company under this act. What it is telling you that we can have a company of one person forming it. We can also have a company of more than one person forming it. Please, I hope you've understood it.
Yes, sir.
Now, what do we mean by a company limited by shares? When you go through section 7.2, it says that a company limited by shares is a company which has the liability of its members limited to the amount unpaid on the shares respectively held by them. Now, this is the explanation for it. When we say you have a limited liability, assuming
Please, sir, your
that
screen is off. Oh.
my
Yes.
screen is off.
Yes.
Because I'm making reference to so many things. So, is it okay now?
Yes, sir.
Is it okay now?
Yes, sir.
Okay. So we not only am I referring to, I was also referring to the act itself. I was also referring to the act itself. The act talks about the liability of the members are limited to the amounts remaining unpaid on the shares, if there are any. So, assuming you establish a company, or a company is established, and you decided to subscribe to shares of 1,000 with a value of, let's say, 2,000, and you paid for, let's say, 1,005. How much is left? 500. Now we say the company owes, and we are about to sell the assets of the company to the free. You, as a member, what will be your contribution? Because your liability is limited. Your liability, the only amount they can take from you is that 500, which you are yet to pay, which is part of the shares that you decided to subscribe to, and for which you are yet to fully pay. So once they come to you and you pay that amount, that is the end. There is nothing more that they can take from you. And that is one of the advantages. You have limited liability. Once they do it, and they sell every asset of the company, and if they're still unable to pay for the assets, the liabilities of the company, you don't care about it. The only thing that you care, or the only thing that you be called upon to contribute, will be that amount which remains unpaid on the value of the shares. And that is a key characteristic of a company limited by shares. Understood? So when you read section 7.2 of the Acts, that is A, that is what you see there. Who can read the section 7.2? Yes, I want someone to read the section 7.2. Please, who will help us?
Sir, I'm reading.
Okay.
The 7.2B.
I have a B.
Yeah, B. It says a company limited by guarantee is a company which has the liability of its members limited to an amount that the member may respectively undertake to contribute to the assets of the company in events of it being wound up.
Wound up. Okay. Now, what does this also mean? If you want to become a member of a company limited by guarantee, for you to be admitted or on the point of admission, you have to make a pledge. You have to make a pledge that today if we are calling on members to make a contribution, this is the amount you make. And that pledge is made at the point of entry. So when it comes to the company owing people, where they want to sell the assets of the company, or where the company is about to die, and they are retrieving everything about the company, your only liability would be the amount you promised to contribute at the time of your admission to become a member of such a company. Understood? So assuming that your class, you want to establish a company limited by guarantee, for me to be admitted, I have to make a pledge. I have to guarantee that tomorrow, if the company is being wound up, that is, if we are selling all the assets or people are claiming, demanding for money from the company, the only amount I will contribute is 20 Ghana cedis. And that is what I have to pledge before I can be admitted to become a member of that company. So when it gets to that point, my only liability is to pay that amount that I pledged to contribute to the assets of the company. And that is what explains a company limited by guarantee. Understood?
Yes, Doc.
The third one, can someone read the C? 7C.
An unlimited company is a company which does not have a limit on the liability of its members.
So what it means is that you realize the first two, there is a limit. If it is about shares, if you owe, if it is about guarantee, what you promise to contribute. But for unlimited liability, you don't have any limit. It is just like someone running a sole proprietor and owing you, and you saw that the person is having a fridge. You can take the fridge and sell, because the person do not have a limit to his or her liability. In that instance, should you see me driving a car and you can identify me as a member of the company, you can seize my car, because there is no limit to my liability. Understood? And that is the third type. What about D?
So please, I have a question.
Please kindly ask.
With the guarantee, please, when the person makes the promise, does that mean that management or the directors can deny him of it, or probably the promise that the person will make will be very small?
No, there
Can he
is,
be
I
denied
only
of it?
use that as an example. There is a statutory amount that you are supposed to pay. There's a minimum amount that you are supposed to pay. So
Okay.
your guarantee should either be the minimum amount or more than the minimum amount, as the members of the company will agree before you can be admitted to be part.
Thank you, sir.
Understood? So
Yes, sir.
for you to be part, then you must meet that minimum amount at worst. What about section 7D? 72D.
An external company is a company as defined in section 329.
So what it means is that for you to be able to explain what an external company is, you have to go to section 329. Please, are you getting it?
Yes, Doc.
And what is under section 729?
Section 329.
329, sorry. What is there?
Doc, we are still searching.
Meaning
Okay,
of
someone.
external company.
External company.
Very good. Okay.
1.
Okay.
Sections 3302, 342 apply to external companies as defined in this section.
Okay.
2.
Mm-hmm.
An external company is a body corporate formed outside the Republic which has an established place of business in the country.
So let's take note of one key feature of an external company. What it means is that the processes leading to the incorporation of that company did not happen in Ghana. So, for example, MTN, South Africa, I'm only using this as a hypothetical situation. Assuming the processes leading to the incorporation of MTN happen in South Africa, but MTN has a place of business in Ghana, then we can refer to MTN as an external company. However, if the processes leading to the incorporation of the company started in Ghana, then we cannot refer to MTN as an external company. So once the processes, so all that we are saying is that the processes leading to you, your mother giving birth to you, should have not been started in Ghana. They should have been started in somewhere. So when your parents traveled to South Africa, they met and they initiated the process. And you are all adults, so you know what they do to start. So once they initiated the processes and you were downloaded in South Africa and later brought to Ghana to start your schooling, are you a Ghanaian? I'm asking, are you a Ghanaian? So you are not a Ghanaian.
Yes. So no.
You are not a Ghanaian. You were born in South Africa, but you are doing your things in Ghana. And that makes you a foreigner. And so in that context is how we define an external company. And that is one of them. Continue.
3. The
Yes,
expression. The expression in quote. 3. The expression in quote. Established place of business, unquote, means a branch, management, share, transfer, or registration office, factory, mine, or any other fixed place of business, but does not include an agency unless the agent has and habitually exercises a general authority to negotiate and conclude contracts on behalf of the body corporate or maintains a stock of merchandise belonging to that company corporate from which the agent regularly fills orders on behalf of the body corporate.
Good. So are you okay now? Please, are you okay with it?
Yes, sir.
Okay. So when we talk of types of companies in Ghana, per section 7, 2D of per section 7.2, we are talking about limited by shares, limited by guarantee, unlimited liability, and an external company, where we made reference to section 329, and then subsequently section 330. And then we went through that it must be established outside Ghana, but an established place of business in Ghana. And they went further to define what we mean by an established place of business. Section 7.4 says that all the companies that we have listed above can be private and can also be public. So what it means is that we can have a public company limited by shares, private company limited by shares, a public company limited by guarantee, private company limited by guarantee, public or limited liability company, private or limited liability company, external public company limited by shares, external private company limited by shares, and it goes on. So when you are asked to explain the types of companies and you don't want to be repeating as I was doing, all that you can do is section 7.1 talks about limited by shares, limited by guarantee, unlimited external company. Then you say under section 7.4, any of the above can be or may be private or public. Then you don't have to say private company limited by shares, public company limited by shares, public company limited by guarantee, and so on. Are we okay?
Yes, sir.
Yes, Doc.
So we can move on. So far, we have done a lot too. We have done history. We are going about the types of companies. Next is to look at how then do we distinguish and say that this is a private company, this is a public company. Read section 7.5. Section 7.5.
A private company, other than the company limited by guarantee, is a company which, by virtue of its constitution, restricts the right to transfer the shares of the company, if any.
Okay, please pause here. You can see under the 7.5, B, C, D. The things that you are seeing there are features of a private company. Now, when you go further to section 7, subsection 7, it says that a company which is not a private company is a public company. What it means is that any company that do not have those features is considered a public company. So when you are asked, distinguish between a private company and a public company. When you say a private company is A, but a public company is not, you are wrong. I want you to say a private company has restrictions on the right to transfer shares. However, in a public company, there is no restriction on the right to transfer shares. If you don't want to go by this, then go ahead and just list the features of a private company and say that a company with the following features is considered a private company. However, a company without these features is considered a public company. And what are the features of a public company? There's no restriction on the right to transfer shares. There's no prohibition on the company making an invitation to the public. Neither is there any prohibition on the company from making an invitation for you to make money, deposit money with them, or purchase their shares. Are you okay? And the total number of members in the private company is limited to 50. So a company without any restriction on the total number of its members is considered a public company. So I beg you, in essence, when you are asked to explain, distinguish between a private company and that of a public company, you can go straight and talk about section 7.5, which provides for the features of a private company. However, under section 7, subsection 7, a company without these features is considered a public company. What are the features of a private company? The first feature is that there is a restriction on the right to transfer shares if there are what? Any. And that is what makes it private. Assuming, Beard Accounting, we came together to establish a group that we will be using to learn. Can I bring someone outside the group to join our meeting without informing the rest of the members? Can I do that?
No.
Yes, madam. I can't do it. Before I can bring an external person, I have to consult you before you will agree for the person to join. That is the same thing that private companies talks about. We decided as friends to come together to form a company. And we decided to allocate to ourselves the shares that we want to buy. Once we've come to that agreement, you cannot bring any person from outside the group to join without we agree. And that is where we say there is a restriction. there's a restriction on the right to transfer shares. What it also means is that even if I want to sell, I say I'm no longer interested and I want to sell my shares in the company, I cannot on my own take that decision. I have to first make my decision known to the members. If any of them wants to buy in addition to what they hold, they can go ahead. If they don't want, that is when they will allow me to bring an outsider subject to their subject to the members agreeing before the outsider can purchase the shares. And that is when we talk about the restriction on the right to transfer shares, if there are any. Understood? What is the second feature? Please, what's the second feature?
Doc, limit the total number of the members and debenture holders to 50. Not including.
So what it means is that not including one,
persons who are genuinely in the employment of the company.
Okay.
And 2, persons who haven't been formally in the employment of the company were while in that employment and have continued after the determination of that employment to be members or debenture holders.
Okay, let me explain that to you as well. When we are counting the total number of members, it should not go beyond 50. But you and I know, those of you who bought the shares of MTN, are you no more than 50? That's an indication that that is a public company. Let me add another. All listed companies are public companies, but not all public companies are listed companies. True or false? And I want someone to explain to me. All listed companies are public companies, but not all public companies are listed companies. True or false? True or false? Hello, class.
Doc, we are here.
I'm asking a question. I'm saying
Yes.
all listed companies are public companies. That is, all companies listed on the stock exchange are public companies. But not all public companies are listed companies. Is it true? True or false? I will ask this question in your quiz.
Sir, please come again with the question. We are still
The question
talking about.
is, all companies listed on the Ghana Stock Exchange are public companies, but not all public companies in Ghana are listed on the Ghana Stock Exchange. True or false?
So true.
True.
Very good. The explanation stems from the second feature of a private company, where it says that private companies have a total ceiling of up to 50. But when you talk about a company that is listed on the Ghana Stock Exchange, or a company that is registered as a public company, the total number of their members goes beyond the 50. We are talking about thousands, we are talking about millions. Now, in counting the 50, you know there are some companies, as part of a motivational strategy, when you are picked as an employee, to motivate you, they assign some shares to you. And in addition to the salary that you receive, what it means is that if they assign those shares to you and the company makes profits and they are distributing dividends, you will receive some as an employee. And they consider that as a motivation. And you were assigned those shares by virtue of you being an employee of the company. So, assuming the company employs more than 100 people, and each of these 100 persons have been assigned or actually has been allocated or allotted some of these shares. Clearly, you see that in counting the number, there will be more than 50. But here we are not including persons that I have just described, because these are persons who became or who were only allotted shares by virtue of them being employees. Once they cease to be employees, they cannot continue to hold those shares. So when you are counting the total number of members for a private company, it does not include such persons. And those persons who, even after employment, they continue to keep those shares for, it does not include them. So the total number of members for a private company should not exceed 50 members and debenture holders. Understood? Can we move on? The next one. The last
the next
two.
one.
Yeah. So that one you can make it together. You can just use prohibited. The first prohibition is that they cannot invite the general public to subscribe to their shares. Neither can they invite the general public to deposit with them money. So that one, once remember prohibition. Prohibited from inviting the general public to purchase their shares. Prohibited from inviting the general public to deposit money with them. Understood?
Yes,
so these are the features of a private company. Are we okay?
Doc, sir.
Yes, sir.
So sorry, Doc. My system just went off a little. I didn't hear the private side you were saying, sir.
I'm saying that. Can you come again so that I'll be clear on it?
Yes, you were talking about private something, and I went off a little.
Okay, what I was referring to is private companies. Private companies. And we made reference to Section 7.5. And Section 7.5 provides features of a private company. And it indicates that the company with the following features is considered a private company. And the features were the ones that we just described under Section 7.5.1, A, B, C, D. And then the 5.1a was talking about restriction on the right to transfer shares if there are any. And 2, limiting the total number of members to 50. And there's a prohibition on the company from inviting the general public to subscribe for their shares. And they are also prohibited from inviting the general public to deposit money with them, whether payments subject to some payments. And that was what we used in describing the features of a private company. But when you go further to Section 7, subsection 7, it talks about a company that do not, or that is not described here as a private company, is considered a public company. And what that provision is saying is that if you are a company and you do not have any of these descriptions, then we don't consider you as a private company, but rather a public company. And that was why I asked the question that all listed companies are public companies, but not all public companies are listed companies. What it means is that every listed company is a public company because it has more than a total members exceeding 50. And that was what I sought to explain. Are you okay?
Yes, Doctor.
Yes, please. Yes, madam.
Please, the features of the private company.
Yes,
Can
please.
you further explain the BII? My network went off, so I didn't hear the explanation for BII.
Okay. The BII, yes. Assuming, let's look at this from this angle. Assuming in the school that you are teaching, when you come, we allocate or allot to you that as a way of motivating you for you to also contribute to the school. At the end of the day, you look at, let's use a company setting. You have joined a company. Then they say that you get your salary. But at the end of the year, depending on how well the company performs, if we do well and we declare dividends, we will pay dividends. And for you to enjoy some of the dividends, we will allot to you some shares. So as soon as you are employed, it is a policy of the company to allot to you some shares of the company. And that allotment is done because you are now an employee of the company. When you cease to be an employee of the company, you cease to enjoy that right. And so you join, and they allotted you 10 shares. And the company does so well and declare dividends. You'll be paid an amount on the 10 shares that was allotted to you. But remember that you are holding those shares because you are an employee of the company. And assuming the company employs more than 50, then it means that they are violating, if we are to include those total number of employees, that means that there will be more than the 50 that the Act has described. But remember that in your case, those shares that you are holding is because you are an employee, not because you have bought and made a contribution towards that. And so when we are counting the 50, it excludes persons in that category. Is it understood? The second part talks about persons in that category who may have ceased to be employees, but still the policy allows them to enjoy. And they could also be more than the 50, because maybe that is what the company wants to do, to acknowledge the contribution of these past or former. And so in that regard, when we are counting the number, it excludes those people. And that is what the BII sought to explain. Are we okay?
Yes, Doc.
I hope you are okay. So we can continue. So we can then say that a company without these features is considered a public company. And that is what we just explained. For an external company, we explained under Section 329. And I think when we went to Section 329, your place, you should have been incorporated outside Ghana, and you should have had a place of business in Ghana. So I think that one we can explain. Is that the case? Now, let us look at each of them. And for this morning, we may end with, I want today for us to, we'll break or we should continue, because if we connect, means that we've been online for 2 hours continuous. Normally, I want us after 2 hours, we break for some few minutes and come back and then continue. Because I want us to finish with promoters and the pre-corporation contracts and related matters, so that at least we cover substantially. Then I can give you a reading assignment, so that God willing, next week we can meet and advance further. So you can see on your screen the difference between private and public company, which we just explained. Are you okay? Now,
yes, Doc.
in Ghana,
Yes, Doc.
and this is also an area that I like asking questions. So please, after the entire lecture, don't ask me areas, because in the course of the lecture, I will tell you the areas that I'll be asking my questions from. Remember, when I was explaining the history, I highlighted some areas that I'm interested in. That you cannot talk about history of company law and forget about the name Professor Gawa. And you must remember the full name of Professor Gawa, Cecil Bartlett Gawa. You must remember. We've spoken about types of companies under Section 6, where it talks about one or more persons can form a company. We've spoken about Section 7.1, where we spoke about the types of companies. We've spoken about Section 7.2. We've spoken about Section 7.5, where we make a distinction between private and public company, which is further concluded under Section 7, subsection 7. We are now looking at how do you convert a company limited by shares to a company limited by guarantee. Kindly take note. The Companies Act allows one to convert a company limited by shares to guarantee, but it does not allow for the reverse. So take note too. And in essence, I will give a scenario and ask you to advise the person on the processes that the person can follow to convert a company limited by shares to a company limited by guarantee. So you have one question for your end of semester. So we've started the end of semester. So don't tell me areas, because if you do, I will not mind you. And that is why I have started giving you the areas. So all that I want you to do is that anytime I say I will ask a question on this, make your notes and make your notes and put it down, write it somewhere. I beg you. And when you are learning, you lay emphasis on it, because I will ask you a question on it. Understood? Understood? So I hope you've noted this particular thing now. So a company limited by shares can be converted to a company limited by guarantee. And for that conversion to take place, certain conditions will have to be met. And you can get that from Section 9. Section 9. Those who want to, you can follow from Section 9 of the Acts. Section 9 of the Acts. Three conditions have to be met. What are these three conditions? One, there shouldn't be any liability on shares, and that all shares will have to be fully paid for. Remember that the liability of members limited by shares is that they can have some amount remaining unpaid. But for you to be able to convert, we should not have anybody, we shouldn't have anybody having any amount that is remaining unpaid on their shares. So it means that every member of a company that wants to convert from limited liability company to a guarantee must ensure that they do not owe. Please, I think I escaped something. I did not explain what we mean by company limited by guarantee. Or I explained. Remember, we spoke about profit making and profit making. Companies limited by guarantee cannot carry on businesses for the purposes of making profits. They cannot make profits. And so when we talk about non-profit making, companies limited by guarantee comes under that. And that for purposes of performing, they cannot engage in any business that seeks to make them profit or where they can make profits. But they can only engage in businesses that further the purpose for which the company was established. It is not to make profits. So if it is a charitable organization, anything that will enable them do the work of charity. But anytime they make a profit, it becomes illegal, because that is not part of the processes that led to the issuance of their certificate of incorporation. So let us take note. And the reason why company limited by guarantee cannot be converted to company limited by shares. You cannot start something and say that I'm a charitable organization, and the next minute you want to start making profit. The law sees that people can use that as a conduit to deceive people with a good name and later transition from a good name to making money, like what some of our churches have been doing. That we are preaching the gospel. By the time you realize the gospel has now turned into everyday harvest, and it now becomes a profit-making venture. And most of them even forget that the reason the church was established was for salvation. This is just for purposes of illustration, and I do not mean to denigrate any church, so that you don't take me on. I beg you. I only use that for an explanation. And so when you come under the umbrella of guarantee, the law does not, because the law sees that if you transition from charitable organization to profit, it will amount to a deception. And they see that as unconscionable, and that's why the law do not. But you can start as a profit and later transition to a charitable organization because the public will see that you have a goodwill, and having gotten the goodwill, you want to give back to society. That one is permissible, but the opposite is not. Understood? So for you to convert, the key condition is that, yes, please.
Okay, so in some there is one, let me say an NGO who the man started with that I want to provide or establish school for orphanage. So he got sponsors from outside and they established the school. So for the whites, they know he's just giving the opportunity for the orphans, so they are not paying anything. But I got to a time when the community, he also enrolled the people in the community and asked them to pay an amount of 10 cedis, not as school fees, but as what did he say? Is it feeding fee or something?
Okay.
Can that one also be seen as the guarantee being converted into the limited?
No, no. As you rightly said, he described the 10 cedis as feeding. So what it means is that look at how much they spend to feed and how much the students are paying as feeding money. You cannot construe profits from the amounts. But when it gets to a point where the amounts, and look at the market rates for private school, how much they pay as feeding money. So when you look at it, and you can compare the amount that they are paying to that of the profits making ventures, the amount, and you can, it can be equal to, then one can construe and you can make a report, and the directors of that company will be dealt with because it becomes illegal at that point. And there are sanctions for that. So it cannot, because they came under the umbrella that we need to, and that is why they said they can engage in a business that is to help them further their course, to continuously or to continue to provide the charitable work that they are engaging. So in that regard, if the things this will help them to sustain the business, but not to make them make profit, then the things this is accepted. Is it understood?
Yes, sir.
Okay. So the conditions that has to be met, the first one is fully paid. The second one is that every member of the company limited by guarantee must agree to the convention in writing. You don't agree with your mouth. You must agree in writing to surrender. And that surrender must be done voluntarily. And you must also agree to cancel all your shares. And subsequently, there must be a new constitution. Remember, when you're operating under a company limited by shares, the constitution allows you to trade for profit. But if you come under guarantee, you are not to trade for profit. So you cannot use the same regulations under limited by shares to do business under limited by guarantee. And that is why they said you need to have a new constitution which is appropriate for companies limited by guarantee. And then once that comes, the members must agree to make a contribution in writing to the assets of the company, the event of the company being wound up. And that was the question one of us asked. What if the amount they contribute is small? And remember that they need to make a contribution to an amount of money, not less than that prescribed by fees. And so the fees that they are supposed to pay will be there. And they are not supposed to contribute any amount less than the prescribed fee. Then subsequently, they are supposed to deliver to the registrar for registration a statutory declaration by the director and the company and confirming that they have met all the conditions that we've stated. Then subsequently, the registrar shall issue a new certificate of incorporation. And that is an indication that the company has been converted to a company limited by guarantee based on the contents of the certificate. So that brings to an end how you can convert a company limited by shares to a company limited by guarantee. Understood?
Yes, Doc.
Yes,
okay. So when you go through it, you can see the suffixes. That is what must follow. It goes on to say that once it becomes a company limited by guarantee, the company shall not change the name under the name it was registered. It only have to add the LT. That one will be LT limited by LBG. So it has to have that at the end of the company to indicate that it is now a company limited by guarantee. And that brings to an end our discussion on the formation of companies. Subsequently, we are going to look at promoters and pre-incorporation contracts. Should we continue or should we pause for some few minutes so that those of you who want to take some cocoa, because it's almost 9 o'clock, you can take your cocoa, after which you can come back at 9. Let's say it's 8:55. We can give ourselves 10, maximum of 15 minutes. We can come back and then we'll continue. What do you suggest?
Yes, that will be okay.
A break.
So let's give ourselves, at least you can see all that we've done this morning is to look at the historical development and to look at the general overview of what a company is, the features of a company, the advantages and the disadvantages. And then we went further to describe the types of companies, and then we've described all of them. We know the distinction between a private and a public company, and we know the processes that we are supposed to follow if you want to convert a company limited by shares to a company limited by guarantee. So we can break with this, and when we come back, we will introduce other things to it to end our first meeting. So we'll be back.
Please, before that, so the steps are the 4 points you just mentioned.
Oh, sorry, I had muted myself. Sorry. It is all the processes. The last stage of the process is the issuance of the certificate of incorporation, and we say that consummates the process, and so the conversion becomes complete upon the issuance of the certificate of incorporation by the registrar, and that issuance means that the registrar would have satisfied himself that you have met all the conditions and have followed religiously the processes as set out under Section 9 of the Companies Act. Are you okay?
Yes, sir.
So in our next meeting, we shall be looking at pre-incorporation contracts and issues of incorporation. And I think after that, we can end our first meeting. And then I'll give you the reading assignment for the second meeting before we meet, where you will have to do that for us. So you come back after what do you call it? It's now 9 o'clock, so 9:50 we are coming back.
Okay, Doc.
Okay. Bye-bye.
Bye.
Okay, ladies and gentlemen, we should be back by now. We should be back by now to now look at issues of incorporation. We are done with the formation and related matters. We should be moving towards we'll be moving towards the second one, which is pre-incorporation contracts and the related matters. We'll be looking at that shortly. I hope all of us have taken something and we are okay now. Okay, I hope who tried to call. I hope it's not a minute. Okay, so we'll be looking at pre-incorporation contracts, the processes of ratification and the rest, and then we can end this morning's class. We can end the morning's class after this. Now let us look at pre-incorporation contracts. Please, are we back?
Yes, sir.
So all of us are on board?
Yes, sir.
Okay, then that is okay. I want to get the second slice on the page that we can, so that I can project. Let's just 21 slides and we will be done. Okay?
Yes, sir.
So that you can continue what you were doing. So that you don't blame me that because of me you did not eat your watch.
This way.
Okay. So I want to, so how do I stop presenting? So, and then I have the promoters. Okay, so I hope you can see what is on the screen.
Yes, Doc.
Okay, we are now going to take our minds to section 10. We'll be going to section 10 to look at some few issues. Remember, section 9 dealt with the conversion of a company limited by shares to company limited by guarantee. And now we are going to look at promoters. And so for you to understand promoters, we need to, for us to proceed, we need to explain who a promoter is. And those with the acts, section 10 coming downwards, that is what we are going to look at regarding the promoter. Now look at the definition of section 10. It talks about who is a promoter and who is not a promoter. That is what the definition does. Section 10.1 talks about who a promoter is. Section 10.2 talks about who is not a promoter. And so when you are asked to define a promoter, your definition must explain who is and who is not a promoter. Now, if you read the case of Pycroft versus Grant, and here we are introducing some of the case law. Remember, We spoke about the statutory, that's the statutory or the legal, the statute. That is the act, case law, and then also the theoretical underpinning. And so now we've looked at the statute, at least some snippet of the statute. That was what we are making reference to when we were explaining the types of companies. What an external company, we made reference to 329, 330, and then the rest. Now, in the case of Tycross versus Grant, they defined who a promoter is, that someone who undertakes to form a company with reference to a given project and to set it going and fix the necessary step to accomplish that purpose. In the case of Tycross versus Grant, that was how the courts defined who a promoter is. But in the Act, that is the Act 992 of 2019, Section 10.1 defines who a promoter, that someone who is or has been engaged or interested in the formation of a company. So it says someone who is. Assuming I'm interested in forming a company, assuming, let's say, Leticia is also interested in forming. So I engage Leticia, please, let's come together to form a company. And so after the engagement, Leticia also gains an interest. Then myself, Leticia, we are all promoters of the company. But in doing that act, we saw, is it Benedict or Chris? I wanted to use names on the platform. Assuming in doing that, please a minute. In doing that, we saw Williams. So I've used Leticia and myself that we had thoughts that we want to establish a company for ourselves. And so the thought came. And I started and engaged Leticia, who also gained good interest in it. And we decided to establish a company. But for us to be able to operationalize the establishment of the company, we needed a lawyer. We needed an accountant. And I realized that Afiba is a well-known lawyer. So we then approached Afiba in her chambers that myself and Leticia, this is what we want to do. And can you assist us as a lawyer? Then Afiba now comes in and provides legal service and charges us a fee for the service that she has provided for us. And after providing that service, myself and Leticia, with the help of Afiba as a lawyer, we were able to incorporate a company. Looking at the scenario, whom can we identify as promoters in this scenario? Using Section 10.1 and Section 10.2. Now I'm going to list the names, and that is how I will ask in the quizzes. I'll give this scenario. Dominic and Leticia are interested in the formation of a company. To be able to do so, Dominic first engaged Leticia, who also shown interest, and together they came together to start operating a company. However, in the process of formation, they needed a lawyer and found Afiba, who assisted them in the process of forming the company. And through the services, the legal services of Afiba, who was paid that legal service, Dominic, Leticia were able to incorporate a company. Now, how do you classify the following as being promoters or not being promoted in reference to Section 10.1 and 10.2? Dominic, do you consider Dominic as a promoter in making reference to Section 10.1 and 10.2? Class?
Yes, Doc.
Do you consider Leticia as a promoter in reference to Section 10.1, 10.2?
10.1.
No.
So, what about the services provided by Afiba? Do you consider Afiba as a promoter or not?
No.
He's a promoter in 10.
Is Afiba a promoter or not?
She's not.
A promoter. He's not.
Afiba is not a promoter per the provision of Section 10.
Thank you.
Remember, Afiba provided legal service for which she was paid for. So in that case, Afiba assisted us in her professional capacity. And in that regard, we cannot consider Afiba as being a promoter. Is it understood? I'll give another scenario where Afiba will provide professional service. But the professional service is to contribute, is to use that as a contribution to Dominic and Leticia to get the company incorporated. So she will not, in this second scenario, let me put it. So Dominic and Leticia are interested in forming a company. Then they approach the services of a lawyer who is Afiba. And upon explaining the content, Afiba also shows interest and says, I'll use my professional expertise for us to combine forces to get the company incorporated. In that regard, Afiba did not charge for the service that he provided and indicate that the services is a contribution towards the incorporation of the company. Can we consider Afiba as a promoter or not?
She's a promoter.
She's a promoter.
Very good. But realize that she does not come under Section 2 because even though she provided professional service, that service that she provided was to assist Dominic and Leticia to get the company incorporated. Unlike the earlier example where she provided a professional service and was paid for that service. That is the distinction. And that is something I want us to take note of. So a promoter is someone who is interested, who has been engaged in the formation of a company, excluding anyone who acted in his or her professional capacity in procuring the formation of the company. And that is why you need to always make reference to Section 10.1 and Section 10.2. So if you were a promoter, what are your duties? Your duties have been explained here. And when you go through Section 10.3, it talks about the duties of the promoter. So it talks about standing fiduciary relationships with the company, having procured the working capital has been raised. The rest is that the promoter is supposed to perform. Standing fiduciary, utmost good faith, compensate the company, and the promoter that acquires information, whatever, it goes on and on and on. So when you are asked to explain the duties of the promoter, remember Section 10.3 ABC, Section 10.4. Then very soon, you'll be moving on to something you'll be referring to as pre-incorporation contracts. Now, you look at it under Section 11, but you realize that even though you'll be going to Section 11.1, you will come back to Section 10.5. And the Section 10.5 will be making reference to ratification of pre-incorporation contract, having made reference to Kellner versus Buster, which is used to explain the common law position, which the current act has moved away from. Now, when we talk about pre-incorporation, as the name suggests, pre-incorporation, activities or contracts that are entered into by the promoters on behalf of the company before its formation. Now let us look at the first scenario. Dominic, Afiba, and then Leticia. For us to be able to incorporate the company, we rented an apartment. And the intention is that the rented apartment shall be used as the offices of the company when we receive the certificate of incorporation. How do we term such a contract that was entered into by Dominic, Afiba, and Leticia with the landlady? With the landlady. How do we term it? per the definition of pre-incorporation contracts. We term such a contract as pre-incorporation because we realized at the time when the contract was entered into, the company that myself, Letitia, and Afiba wanted to form had not yet been incorporated. We had not yet been given the certificate of incorporation. And in this regard, we refer to that contract as a pre-incorporation contract because it was formed before the formation of the company. And the idea was that we were supposed to use that company and we were supposed to use the rented premises as the head office of the company. And it is part of the requirements because you need to have a registered office. And you cannot have the registered office after. You need to have it as part of the processes leading to the incorporation. So it means that even before the incorporation of the company, you will have to undertake certain contracts, and which is the pre-incorporation contract. And so Dominic, Letitia, Afiba engaging a landlady or landlord to rent an apartment intended to be used as the head office of the company, we classify that arrangement, that contract, as a pre-incorporation contract. Is it understood? And that is what section. And that is what section 11 of the Act talks about. And the section 11 says, 1, a contract or any other transfer reporting to be entered into before. And so we make the definition of pre-incorporation contracts. Now, what is the position of the common law? Common law, we are looking at the British position. The position of the British then, which was espoused in the case of Kellner versus Buster, that's a wine case, was that a non-entity cannot have an agent. And what do they mean by a non-entity? Remember that Dominic, Letitia, and Afiba entered into the contract to get a rented apartment as the head office of a company yet to be incorporated. So the presumption is that we were doing so on behalf of the yet to be formed company. And that makes Dominic, Letitia, Afiba agents of the yet to be formed company. The British position was that how can such a person that we've not given birth to have an agent? And so under the British law, it was impossible for such a contract to be done. And to them, they outlawed such contracts as not being a valid contract because something that is deemed not to exist cannot have an agent. And that is part of the things that Professor Gawad did that brought about modification. And that is where when you read section 11.2, it says that when you read section 11.2, which is the effect of ratification, and then section 11.3, that is proud ratification. What it means is that the effect of such a contract, assuming after we had engaged the landlady, we refused to pay, but the company that we formed, which became Dominic & Co. Company Limited, had been established. And they were using, Dominic & Co. is using the premises that we rented from, let's say, Awate. Awate is the landlord. The contract was entered into with us. So Awate is the landlady or the landlord. And the Dominic & Co. Company is now operating. Dominic, Letitia, and Afiba refused to pay any amount. But our company is the one using it. Should Awate sue, who would be liable to pay? Should Awate sue, who would be liable to pay? For us to be able to understand who will be liable to pay, let us avert our minds to section 11.2 and section 11.3 before we can go back to 10.5. I hope you are following the narration.
Yes, sir. Yes, sir.
Now, so we have gotten to the stage that
The rented apartment is now being used by Dominic and Co. Company Limited. But Dominic, Letitia, and Afiba did not pay the agreed amount when the agreed amount with Awate, who is the landlord. Now, Awate is aggrieved. Whom should the suit be directed to? Can Awate sue Dominic and Co. Company, or can Awate sue Dominic, Letitia, and Afiba? And I am saying that for you to be able to answer, you need to avert your mind to section 11.2 and 11.3. Let's look at section 11.3. Who can read it for us so that you can answer that question for me?
Section 11.3. Before ratification by a company, the person who purported to act in the name or on behalf of the company is, in the absence of express agreement to the contrary, personally bound by the contract or other transaction and is entitled to the benefit of the contract or other transaction.
Okay, so Awate has sued. Who will be responsible to pay per what you have read? Is it Dominic and Co. Company, Dominic, Letitia, and Afiba? Who should pay?
I think it's Dominic and Co. Company.
Excellent. Why are they supposed to pay? Because the company is yet to accept responsibility for what we entered into with Awate. And that is what referred to as ratification. If the company ratifies, then we come to section 11.2. That is where the company shall become bound. And that is when the company will now owe Awate. But prior to the company ratifying, as in the present scenario, that is when section 11.3 becomes applicable. And if section 11.3 becomes applicable, then Dominic, Letitia, and Afiba are the ones that the suit should be directed to. Is it understood? Is it understood? Please, is it understood? Have you understood it?
Yes, yes, Doc.
Yes, Doc.
So what
Doc,
must happen? What must happen for the company to, yes, sir.
You say, Doc, so if I'm to understand what you are saying, it means that the section 3 is the process to ratification.
No, section 3 says that if at the time of the suit, the company had not accepted responsibility, which is the ratification, you will be going to the process. The process are section 10.5. This is the effect. The 11.3, 11.2 and 11.3 is the effect of ratification or non-ratification. Ratification in this sense is the company accepting responsibility. So section 11.3 is saying that before the company accepts responsibility, then it is the individuals that entered into such a contract on behalf of the company that must be held liable, which is in conformance with the British position as espoused in the case of Kerner versus Baxter. But the shift from the British position is what section 11.2 indicates, that if the company accepts responsibility, which is contrary to the position of the British, that the non-entity cannot have an agent. But the Ghana Companies Act is saying that at any point, once the company becomes operational, they can accept responsibility for actions that were done preceding their incorporation. And if they accept responsibility, they are to enjoy the full benefits of that transaction as if they were the ones that entered into that transaction. And in that case, if Awate sues for the rent, it is rather Dominic and Co. Company that has to be sued that have to be sued and be asked to pay for the rent as per the readings of Section 11. Is it understood? But prior to ratification, that is when the suit will have to be directed towards Dominic, Letitia, and Afida, because at that time, the company was yet to accept responsibility for our actions. Once we understand this, then we can then move on to, so if the company wants to ratify or accept responsibility, what processes must they go through? And that is what Section 10(5) of the Companies Act explains. And what that Section 10(5) says? Can someone read to us?
A transaction between a promoter and the company may be rescinded by the company unless after
A transaction
unless
by the
Someone
company
is reading.
unless
A minute. Someone is already reading.
okay.
A
Only one
transaction
person should
between
read.
a promoter and a company may be rescinded by the company unless after full disclosure of the material facts known to the promoter, the transaction has been entered into or ratified on behalf of the company.
So that is before the company can ratify. What it means is that at any point, the company will not accept responsibility. They can only accept responsibility when there has been full disclosure. So for Dominic and Co., which is now the company, to accept the responsibility to pay the rent of the contract that Dominic, Letitia, and Afiba entered into with Awate for the release of his premises to be used as the operating head office of Dominic and Co. Dominic, Letitia, and Afiba, we will have to make full disclosure of all material facts. Full disclosure of all material facts. And once we make that full disclosure of more material, that is when the company, Dominic and Co., can ratify. And that is when you go through further, who can do the ratification? They talk about the board of directors of the company, if all the board of directors of the company are independent of the promoter. Then they talk about by all the members of the company or by the company at a general meeting, at which neither the promoter nor the holders of the shares in which the promoter is beneficially interested have voted on the resolution to enter into or ratify that transaction. Understood? So, Dominic and Co. can ratify, the board of Dominic and Co. can ratify the contract that Dominic, Letitia, and Afiba entered into. If after the incorporation of the company, none of us is made a director. So, but if any of us is made a director, then the directors cannot, because in that case, the promoters are not independent of the directors. But if none of us after the incorporation is made a director, then the directors of the company can do so. Other than that, the ratification can only be done by all the members of the company. In that case, my Dominic, Letitia, Afiba, we could be members of the company. But on the day of ratification, we will not be allowed to speak or vote on the matter, because if we do, it will amount to conflict of interest. And that is what the 10(5) ABC talks about. So having made the full disclosure, the board can do it if none of us was appointed as the board. In that case, the board is classified as independent. But if any of us was subsequently appointed as a member of the board, then the board is barred from ratifying such a contract. Subsequently, it can be done by only the members. But if the members are to ratify, then anybody, that is myself, Dominic, Letitia, and Afiba, we are members. We will not be allowed to speak or vote on the matter because we have an interest, because we entered into that contract. And in that regard, the members can do it, but excluding our vote. And that is when we will ensure the independence and the objectivity and avoid an issue of conflict of interest. Understood?
Yes, sir.
So we can then make reference to some cases on promoter. So you can talk about the newborn versus Sensolid Limited, where a promoter signed the letter, confirmed an agreement to sell harm to the defendant. He signed it purportedly on behalf of a company which did not at the time exist. The court held that the contract was invalid as the unborn company lacked capacity. This is in line with the British position which was held in the case of Kellner versus Baxter. It is this position that the Companies Act has modified under Section 10(5), under 11(1), 2, and 3. So you realize that under 11, under 10(5), it says that such a contract, there must be full disclosure. And that was what you went through. So a transaction between the company may be rescinded. And that's where we are talking about 10(5). There must be full disclosure. So in this regard, Dominic, Leticia, Afiba, we need to make a full disclosure of all material facts that are known to us but unknown to the company. Once you make those full disclosures, then the company can go ahead to ratify the transaction. Is it understood? Understood? So,
yes, sir.
Prior to ratification, that is when we can talk about 11(3). And that is when we answered that if the company do not ratify, then our team will have to sue Dominic, Leticia, and Afiba. But if the company ratifies, then our team will have to sue Dominic and Co. Company Limited. And that was what 11(2), 11(3) explains. Understood? Understood?
Yes,
so
Doc.
we are done with promoters and pre-incorporation contracts. Can we continue?
Yes, Doc.
Yes.
So remember, under promotion and pre-incorporation contract, it is also a question in company law that I will ask. And so I'll first ask you to explain what a promoter is, where you have to make reference to 10(1) and 10(2). And I will ask you to explain the common law position and the modification, if any, the Companies Act has made to the doctrine of pre-incorporation contracts. And you can explain the common law position by making reference to Kellner versus Baxter, Sensolid versus Newborn Company Limited. And then the modification comes under 10(5), 11(1), 2, 3. That is a shift from the common law position, where such contracts can be ratified, may be ratified, and the requirements for ratification. So I've given you 2 solid end of semester questions. So don't ask me areas. Don't ask me for areas when we are done with our 4th meeting on the weekend of 29th August. Understood?
Yes, Doc.
Yes, I.
So please, as we are moving, I'll be giving you the areas. So note it so that you don't ask me, say, areas, because I will not be in a position to give you areas, because I will say, areas, I've already given it to you. Now let us look at incorporation of companies, and that is where you'll be looking at the application to get the company incorporated. And we are going to focus on section 12, section 13, and then we can even continue to 14, 15, 16, and 17. And if you don't take care, we might even continue from there to reservation of names up to section 26. It's not easy, but as I said, we should try as much as we can to read. The 1213 is talking about who can apply to get a company incorporated. Remember, originally, the age that one could apply to get the company incorporated was purged at 18, was purged at 21. People raised concerns that it was inconsistent with the age of majority, which allows someone to even vote and elect a president. Why can't such a person who can elect a president also establish a company? Originally, it was at 21, which was similar to the British position. But now we've reduced it to 18. So any person of the age of 18 years and above may apply for the incorporation of the company under Act 992 of 2019. So if you are more than 18 years, you can apply to get the company incorporated. Your application shall be made in the prescribed form and delivered to the registrar. The prescribed form, and that is when we talk about the content of the application. So when you read section 13.2, it talks about the content of what the application should contain. And so it talks about the application shall include the name of the company as required by section 21, which we'll be looking at that. An indication of the type of proposed company, the nature of the proposed business, the address of the business, it goes on the telephone number, the electronic mail, the other particulars of the subscribers, the date, place of birth, and it goes further and on and on and on and on and on, up to 13, A, B, C, D, up to O. The A, B, C, D, up to O talks about the content of the application. And so if you are applying to get the company incorporated, the law says that your application must be submitted to the registrar and prescribed form. The form that is prescribed must contain all the items listed under section 13. Understood?
Yes, sir.
And so once you've made the application and everything is okay, and the registrar is satisfied that the application for incorporation has complied with the provision under section 13.1, subsequently 21, which relates to names, the registrar shall, after payment of the prescribed fee, certify under seal of the registrar that the company is incorporated. And in the case of a limited liability company, that the members, the liability of its members is limited. From the date of incorporation, the company now becomes a body corporate by the name contained in the application for incorporation, and it is capable of performing the functions of an incorporated entity. Then, subsequent to consummate the process. So once it is accepted, if the process has not been consummated, the consummation of the process ends with the issuance of the certificate of incorporation. And that is an indication that whatever you submitted is correct by the registrar, and there is evidence, conclusive evidence, that the company has been duly incorporated under this act. And proceedings shall not be brought in the court to cancel or annul the incorporation. Is it understood? It does not mean that you cannot bring proceedings to wind up the company. You can do so under section 16. Is it understood? So that is how a company is incorporated. So we are done with about 4 things this morning. We've gone through the history. We've gone through the we've gone through the processes, the types of companies. We've gone through what we mean by promoters for incorporation contracts. And this morning, we've been able to incorporate a company where the process is consummated by the issuance of the certificate of incorporation under section 15. Any other questions? Per the course outline, I want to look at the course outline, look at the next. Where is it?
So your screen is off.
Yes, I'm now looking for the course outline. I'm done to see what is next. Media, I'm done. I'm done with the content. Let me a minute. The course outline is here, which I'm going to forward to you. So I want to be sure that we've completed everything we have to complete. So we have completed the first part. We are only left with names, companies, reservation, which we can continue. So that at least by the time we are done with the names, so we are supposed to continue with sections 18, section 19, 20, 21. So please, I'm done with the second part. If there is any question before we move on to names and other related issues. Any questions so far? Please, any questions so far? Hey, you people are not talking. I hope you are there.
We are here.
We are here.
Okay.
We are listening.
Now you are listening, eh?
Yes, sir.
So now let us look at names of companies. And there you'll be looking at section 21. Let's look at section 21. I'm going to project it so we can see section 21. Okay, you have to look at names. Name of a company. So based on the types of companies that we went through, and we are saying that every company must have the name of its choice. And the name of the company or the name of every type of company incorporated is required to have a suffix. The suffix is something that ends it. And the suffix that you are supposed to attach is to make it easy for people to identify the actual legal form by which the company has been registered with, And so you remember we spoke about private companies limited by shares, limited by guarantee, and unlimited liability companies. So for the purposes of registration, if it is a company limited by shares, a private company limited by shares, the suffix should be LTD. If it is a public company limited by shares, the suffix should be PLC. So you realize that GCB Bank now say GCB Bank PLC, Cal Bank PLC. If it is limited by guarantee, then you see LBG. Please don't add T to it, because if you add LGBT, then you are moving on to the realm of absurdity, those who are not reasoning. Then we have private company unlimited by shares. That's where you have PRUC. Then you can have public company unlimited by shares. You have PUC. So you have to take note that if you have this, under section 21, the act requires you to affix or display this name at the registered office and every place of business. And you must have this name engraved on your seal, and any document purporting to be coming or emanating from you, you must have this name mentioned in all those documents. However, there are provisions that speaks against names that the law regards as misleading and undesirable. Names that the law regards as misleading and undesirable. Misleading in the sense that it can make people, it can deceive people. When you register a name like, it's too early this morning, Chesco Company Limited, Chesco Company Limited, these are, they are offensive, and we consider such names as rude or vulgar. So can you register a company with such names that depicts vulgarism, that depicts offensiveness, or that is considered in the eyes of a reasonable man, reasonable person, as being rude? When you look at the case of the Republic versus Registry of Companies, ex parte Her Majesty's Attorney General, which was 1991, where a prostitute attempted, on the advice of her accountants, to register a private company limited in 1979, which had the stated objects to carry on the business of prostitution. Now, the registrar accepted the registration under the name Lindy St. Clair Personal Services. The Attorney General applied to the court to quash the registration on the basis that the name had formed for an unlawful purpose. The court held the registration should be quashed. The reason being that the object did not necessarily involve the commission of a criminal offense. Contract for service of a prostitute would be illegal and unenforceable as contrary to public policy. The company had not therefore been formed for a lawful purpose. And so when we talk about misleading, it means that per the decision in the Sinclair case, we are talking about when you establish a company to do something which our laws frowns upon, the registrar, even after incorporation, can go to court to quash the registration under the name that the company was registered with is undesirable, is rude, and offensive. Again, when you register a name that is confusing, which can easily confuse the general public, the registrar can also come under the law. And remember this Ghanaian case of EP Church of Ghana, EP, Ghana. It came under the misleading, and that was why one of them was asked to change. And so that was why one of them had to write the name in full, because EP Church of Ghana and EP, Ghana could easily mislead someone. And either I may think I am dealing with EP Church of Ghana, and my correspondence may end up at EP, Ghana. Similarly, if you consider the case of Ewing versus Buttercup Matrin, there was something similar. And the case of Exxon Corporation versus Exxon Insurance Consultants, where in all these two cases, the court said that the names were misleading and that it would be difficult for the public to do business with the persons because of how similar the names were. Understood? And so to avoid this risk, the Companies Act says that even before you incorporate a company, you can reserve a name so that by the time the company is incorporated, nobody can take that particular name so reserved. And when you read section 21(6), it talks about fix, where the registrar so directly within 6 months of the company being registered by that name, the company shall change the name within a period of 6 weeks from the date of the direction. It goes on and on. That to avoid the risk of choosing a name that ultimately turns out to be undesirable, the promoters should inquire from the registrar whether the name they intend to give the company is too like that of a company already in the register of companies. So prior to incorporation, you can make that request to the registrar of companies. So after obtaining confirmation, the company's name is a registrable one, depending on the outcome. Then the promoters should immediately make a written application for its reservation under section 22. Once the registrar is okay that the name you intend to register that does not conflict and it is not already in the system, you can quickly write for reservation under 22. And once you make a reservation, it shall be enforced for a period of 30 days or set longer, but it should not exceed 60 days as registrar for special reasons may allow. Meaning that once you make a reservation, you have 30 days to consummate it by going through the process to get the name, or not exceeding 60 days, meaning that you can request for an extension. And the extension is under the discretion of the registrar to either allow or not. But in all, you cannot reserve a name exceeding 60 days. And so every public company must write the word limited against its name, and every private company must write the word private limited after its name, as indicated under section 21(1). I will pause here. If there are questions, you can ask. And if there are no questions, I think I have exhausted whatever I'm supposed to under the first topic of our meeting. Ideally, I'm supposed to go ahead with the second topic, which is about the veil of incorporation. And so that is going to be our reading assignment. Read on what we refer to as the veil of incorporation. However, I'll forward this particular note to you, which explains everything that we have done today.
Doctor, sir.
Everything that we have done today.
Doctor.
Yes, sir.
I was thinking before a business will be incorporated, as part of its processes, the registrar will require the name to be given to the company before the incorporation takes place.
You see, that right is a preserve of the company that wants to be registered. You will have to indicate what name you want. I don't know if you get it. Now, this is the name I want to give. But remember that the name you want to give should be a name that is not considered misleading, undesirable. And so to avoid that, the current legislation says that once you have any intention of incorporating the company and having a name in mind, you can write to the registrar to inquire from the registrar whether the name, your proposed name, is a name that can be registered or not. So following the response from the registrar, if the registrar says that this name, you can go ahead to do it, then you can then write subsequently to the registrar and say that if that is the case, then please reserve this name for me so that no other person. And once you write that the name should be reserved, and for the period that the name can be reserved, no other person can write or incorporate the name so being reserved by you. And you can reserve the name for a period not exceeding 60. That's the maximum period. What it means that within that period, you should be able to register the name.
Okay. Okay.
Are you okay? And
yes,
that is
sir.
what section 21 talks about.
Okay. So,
Okay.
Doc, so in the case where the entity doesn't go through this process and then the company or is incorporated, that is when the registrar can take it to court to forbid you from using that.
Yes.
Okay.
But now the current processes will not even allow you. But people can, through whatever means, can outwit the system. And so when you even outweigh the system, per the decisions in the cases that we spoke about, then the registrar can subsequently go to court to quash it.
Okay.
And using the explanation of the basis as established in the cases that we mentioned.
Okay. So, Doc, follow up one.
Okay.
Let's take it that a name has been registered, the registrar in one way or the other may not have been on the known. And another incorporated company thinks that that name is having something to do with their name. Can that company also sue them or draw the attention of the registrar?
Yes, that is where they can come under the Protection Against Unfair Competition Act, where it protects a company name from being used by another company, where the use of the name causes confusion or likely to cause confusion in respect of another company product or services. Name of a company is jealously guarded by the law, but it is not immutable or unchangeable. The Act provides that the name can be changed by special resolution. And the name, it must come under the approval of the registrar. So at any point, if you realize that that thing is happening, that is when you may go to court. Then that is when they will have to establish who was the first register. Depending on the outcome, then one of them may be directed to change. And when you are so directed to change, you must also go through the same processes to receive approval so that you can get your name changed. And the regulations of the company allows for the change of the name. And it comes under the Section 21 by special resolution. So if you read Section 21, subsection 4, it talks about that. So you realize I use the example of EP Church of Ghana, EP Church, Ghana. And you realize that they have subsequently changed that name. One of them writes the Evangelical in full.
Okay.
And now makes it distinct from the one that used to create the confusion of the minds of well-meaning Ghanaians. Are you okay?
Yes, Doc. Yes, Doc. That's perfect.
Okay. And I hope you've all any other person with a question? So we can now, based on what we have done, I will entreat all of you to read the notes and subsequently read on what we mean by the veil of incorporation and the instances by which the veil of incorporation may be lifted, and the various instances by the Companies Act, by other legislation, and so on, and by the registrar. Kindly try and get it done. After which we can go into the constitution of the company, the effect of the constitution, and then we'll also look at the internal management principle as established in the case of the Royal British Bank Limited versus Pequan. And that's where we talk about the presumption of regularity. And so we can read around it. Okay? So our reading assignment is on the veil of incorporation. And so we can, and in reading, consider lifting the veil pursuant to the Act, lifting of the veil pursuant by the courts, and lifting of the veil by other legislation. So let's read around it together with the Constitution. And so you can go to read. I will as well forward the notes to you. After which we can move on to the officers of the company, look at the company secretary, and then also look at the auditors. Then we can then subsequently look at directors of their meetings and then so forth and so on. So please, if we are to cover extensively on all the listed topics, I would need your cooperation. And the cooperation I'll need from you is that after class, don't close your books. Try as much as you can, following the course outline, to read on what has been directed. There are books that you can buy. Bonzi Simpson PE, that's the second edition of company law in Ghana. You can read on it. You can as well ask for Gawes reports. I can forward it to you. It will be part of the thing that I'll forward. You can read it. That's the Gawes report on Ghana's Companies Code. That is the 1959 report. I'll forward it to you. And read on any textbook on company and partnership law. I beg you, try as much as you can to read. You can as well read on Banks and Specialized Deposit Taking Institution Act 2016, Act 930. That is when you see banks coming under company and also coming under their own regulator. So please, let's try as much as we can to read beyond what we have been taught so that we will appreciate everything that we have been taught. I've already assured you that no one is going to fail, everyone is going to pass. But remember that if all of us are to pass, then it means that we all need to support ourselves and each other. I wish you well. If you have questions, you can ask me. And if there are no questions, then we can call today's meeting to a close. And then I'll give you the reading assignment subsequently. Yes, sir.
Please,
yes, sir.
We thank you for such, and we'll be very proud if any necessary documents that we have to read can be channeled to our platform so that we can do research, whether the link or the name of the document that will help us through this course. We can channel it through
I'm going to do that. I'm going to do that right away. I'm going to push every document you need to have on your platform once the lecture ends. I'm going to do that and make sure all of you have this.
Thank you, Doc.
Okay. Oh, so grateful. I wish you all the best. Have a wonderful weekend.
Thank you as well.
Okay.
Thank you. We are grateful.
Always welcome. Bye-bye.
Bye.
Bye.
Bye.